a decision of the Unified Patent Court of the UPC, in this case here, a decision of the Paris local division of the UPC. This is a case between IMC Création and a company called Mul-T-Lock. As I said already, this is not a case which is SEP related. It is a case that refers to patents that are not standard essential to other parts of the technology, to other technologies. It is, however, also relevant for SEP cases because it deals with a fundamental issue, and this is the question of the long-arm jurisdiction. So far, how far goes the jurisdiction of the UPC? Can the UPC decide about aspects of infringement of patents that are not in force within the UPC territory? So this is the basic question here. And this is, of course, an important question because it draws the line of how, what type of legal protection a patent owner or a claimant can get by the UPC. Here, very quickly, some basic facts on this case. I think particularly interesting here is the patent that has been asserted, because we have IMC that holds a patent, which is a European patent with a unitary effect. That means that this is a patent that is enforced in all of the UPC member states directly. So it's in all of the EU states that are part of the UPC agreement. It has a uniform application, it has a unitary effect, so it's a patent basically that is subject to the UPC jurisdiction. It's clear, so it's some patent that has been made subject to the UPC jurisdiction and has an application to all relevant UPC states. But it is also a patent that goes beyond that. It is a European patent that has national designations in Spain, for example, which is a state that is part of the EU but is not part of the UPC. The patent is also in force in the UK, which used to be a EU member state, is no longer a EU member state and also not a UPC member, and also in Switzerland, which is neither a EU member nor a UPC member. So this patent has been asserted here, which, let's say, involved jurisdictions which were going also beyond the jurisdiction, let's say, the main core territory of the UPC. This patent was used by its holder, by IMC, to file an infringement action against Mul-T-Lock, and it raised claims in Paris, the Paris local division against the French company of the group, Mul-T-Lock, and also the Swiss branch of the company. The reaction of Mul-T-Lock was to contest jurisdiction, not as far as the infringement of the patent within the UPC territory is concerned, but with respect to the national designations that go outside of the UPC territory. So here in the present case, we mentioned that already, it's Spain, UK, and Switzerland. Shortly after that, IMC withdrew the action against the Swiss brand, the Swiss branch. So here we had, at the end of the day, proceedings against a French company that were brought before the Paris local division of the UPC. So this is something to keep in mind, because it is important for this decision here. So there was this contest of the jurisdiction as far as the non-UPC designations of the patents were concerned. And with this ruling here, the Paris local division confirmed its jurisdiction also regarding this aspect, so this non-UPC designations. Let's take a look at the reasoning of the court. So what the court here did basically is to confirm that it has this long-arm jurisdiction, so that it can deal with questions arising from patents that are not in force within the UPC territory. To start with, the court confirmed, of course, a general principle of territoriality, which is applicable when it comes to patent rights. So it did not question that. The court said, of course, if you are bringing infringement claims, then these infringement claims can only refer to countries in which you have patent protection. So where a patent is in force. And this is of course, a fundamental core principle when it comes to patents, the principle of territoriality, and it was not questioned here. So there was also not a real question on that in these proceedings, because if you would make infringement claims with respect to Spain, UK, and the Switzerland, there was a patent in force there. So this is the principle. This continues to apply here. What is different here and what needs to be clarified is whether, of course, the UPC can exercise jurisdiction going beyond, let's say, its borders. And there are rules that govern this question. And for the specific case here, there were two different instruments that were relevant and the court must apply. There is one, the so-called Brussels 1 bis regulation, which is an EU regulation that governs the question of which national courts of an EU member state should have jurisdiction when there is involvement of more than one state in a specific case. So this is an instrument that comes from the EU, which is applicable also for the UPC. And there is a second instrument which is particularly relevant for the present case. It's called the Lugano Convention. This is an international treaty between the EU and the so-called EFTA states, which this is the European Free Trade Association, including Switzerland, Norway, Iceland, and Liechtenstein, which governs very similarly to the Brussels 1 regulation the question which courts should be applicable, should have jurisdiction in disputes where you have involvement of more than one states. And this Lugano Convention deals with the same question with respect to courts in the EFTA states and the EU. So this was the framework that the court needed to apply here. And it's focused on particularly two provisions. I would like just to show you these provisions here so that you can understand the judgment a little bit better. There is one fundamental provision that the court dealt with here, which is Article 4 of the Brussels regulation. And what is also interesting here, the Lugano Convention has exactly the same provision. It's Article 2.1 of the Lugano Convention. What this both provisions establish is that the general principle that jurisdiction is given at the courts for the courts at the defendant's domicile. So this is a fundamental principle of European procedural law, which has been also transposed in the Lugano Convention, that the claim follows basically the defendant. So if we want to apply this in our case here, we have a defendant which is based in France. So basically, under this regulation, the courts in France should have jurisdiction over a claim that has, let's say, links to more than one countries, and this should be also applicable with the local division of Paris of the UPC. So this is the principle. There are, however, exceptions from this principle, and this take particularly the form of exclusive jurisdictions. What does this mean? These are cases in which, for specific type of disputes, the courts of a specific member state shall have jurisdiction, irrespective of whether the defendant is where the defendant is domiciled. So they're both instruments, and here again, the Brussels 1 regulation and the Lugano Convention have identical provisions. Established some exceptions from this general rule that you should have jurisdiction at where the defendant is domiciled. And one exception, which is eventually relevant for patent cases and also infringement cases, is Article 24 of the Brussels I regulation, which says that in disputes where the question is about the registration or the validity of patents and other intellectual property rights, and irrespective of whether this issue is raised by way of an action or as a defense, the courts of the member states in which the right has been granted or is enforced should have exclusive jurisdiction. And this, again, is the same with the Lugano Convention. So this would mean, basically, that for our case here, if Mul-T-Lock would contest the validity of the patents that have been asserted, which are outside of the UPC territory, so the patent that is enforced in Spain, that is enforced in the UK, or that is enforced in Switzerland, the Swiss, UK, or the Spanish courts should have exclusive jurisdiction, which would then, of course, bring the jurisdiction of the Paris local division to fall. Is this the case here? Is this exception applicable in the present case? To answer this question, the UPC looked at the decision of the Court of Justice of the EU that was delivered some weeks before this decision here in the BSH Electrolux case. So we have already looked at this decision here in one of our past webinars, because it's, let's say, the fundamental decision where the Court of Justice of the EU has talked about the issue of long-arm jurisdiction. And what the Court of Justice of the EU said here is that this exception basically does not apply when we have infringement claims being raised. So in the eyes of the Court of Justice of the EU, this exception in Article 24 refers only to disputes concerning registration and validity of patents, not the infringement. So when it's about, let's say, what are the consequences, the legal consequences of an infringement of a patent, this exception does not apply. And therefore, the court at the defendant's domicile, which would be France in our case here, has jurisdiction to decide the case. This applies, according to the Court of Justice of the EU, when we have patents granted in another member state of the EU, but also when we have patents granted in third states. Again, the principle that the jurisdiction follows the defendant's domicile is given here as well. The Court of Justice said there could be exceptions, special rules, maybe from bilateral treaties, etc. But generally, if the decision of the court on infringement includes elements also on the validity, if these elements would be limited to an inter partes effect, meaning affecting only the parties to the specific proceedings and not the patent generally in its validity, and cannot lead, for example, to an invalidation of the patent in a third country, then usually also for third states, this long-arm jurisdiction of European courts will be given. So what the UPC did was to apply this principle here in the present case, to apply this decision, the BSH decision of the CJEU in the present case, which led to the result we mentioned before. The court confirmed its jurisdiction to hear the infringement concerning the Spanish and the Swiss designations of the patent in suit, highlighting, however, that the UPC could stay its proceedings if there is a reasonable, non-negligible risk of invalidation of these patents abroad in Spain or in Switzerland. And regarding also the UK designation, the court also confirmed its jurisdiction, saying that provided that the finding of invalidity in these proceedings will have only inter partes effect, meaning only effect between the parties of these proceedings. It was very clear in the eyes of the UPC that the BSH decision establishes jurisdiction with respect to the Spanish and the UK designations. These are the principles we just discussed. A bit of a question was here, does this also expand to the Swiss designation? And here, because the BSH ruling of the CJEU did not expressly mention Switzerland, it was other third countries. But the court said here this principle you can transpose also to the Swiss designation, not least because the Lugano Convention, which also applies with respect to Switzerland, works with identical principles and exceptions. So it's not something which is totally different. So these principles that the CGEU established can be applied also with respect to the Swiss designation of the patent. So finally, what the court did was not only to apply this principle here, but also to confirm some of the other findings of the CGEU, which I've laid down here, and I think it's interesting to also note. The court, as the CGEU had done, said that the patent owner should be given the possibility to concentrate all infringement claims at a single forum and obtain overall compensation in a single forum, not least to avoid divergent decisions. And also that the rules of jurisdiction should not be very flexible in the sense that they should be strong enough to ensure legal certainty and predictability, and you should not be very much allowing procedural strategy of the defendant to change the jurisdiction of the court, which would have been the case, for example, if you would allow the defendant to exclude jurisdiction of the UPC if it would attack the validity of the patent in another state, here in the UK, in Spain, or in Switzerland. So here, confirmation also of these principles that the CGEU had established already in the BS8's decision. And finally, what the court also wanted to note here is that using this interpretation and establishing long-arm jurisdiction in that respect does not affect, in the views of the UPC, the right of defense or the equality of arms between the parties, because the courts can either stay the trial pending the invalidation silence or restrict the finding on validity inter partes, meaning between the parties of the dispute. So what we can take from this decision here is that the UPC confirmed that it has long-arm jurisdiction, and insofar it followed very much the guidance that the Court of Justice of the EU had provided some weeks before this judgment was delivered here. And of course, it's going to be interesting to follow up this case law as it develops, but there had been a decision of the UPC also before the CGEU had delivered its ruling in the BSH case, which applied more or less the same principles. So there are good chances that this view of the UPC regarding the long-arm jurisdiction will become, let's say, more settled as the time passes. But again, this is something we will need to monitor and to look at if we have also decisions from the Court of Appeals in the future. And of course, if we have, then we're going to cover that and report here as well.